and the government, the union government, is considering impeachment charges against Justice Yashwant Varma. Remember, he's the same High Court judge, the Delhi High Court judge, from whose home burnt bundles of cash were allegedly found in the month of March. The piles of charred cash, photos of which were shared online by the Supreme Court, were discovered by firefighters in the smouldering remains of an outhouse attached to his allotted bungalow in central Delhi. Justice Varma, though, has firmly denied any link to the cash, calling allegations of impropriety against him and members of his family preposterous, and has spoken of a conspiracy against him. He has also refused to resign despite a damning report by a 3-member judicial panel. Earlier this month, President Draupadi Murmu was advised to begin the impeachment process, and sources in the government are now saying that the impeachment process will likely begin in the second half of July, when the parliament convenes for the monsoon session, unless Justice Varma himself decides to step down before that process begins. We have a panel of top legals joining us on the show tonight. But before I bring in other lawyers, let me bring in senior advocate Arima Sundaram, who's joining us first. Mr. Sundaram, really appreciate your time here on NDTV. The impeachment of a judge is a rare and serious constitutional exercise, sir. What safeguards exist within Article 124(4) and the Judges Inquiry Act of 1968 to ensure that the process remains fair, impartial, and at the same time not politically motivated?
You must realize one thing, that the Constitution deliberately brings in an elaborate procedure before you can impeach certain high constitutional functionaries, including judges of the High Court, Supreme Court, in the sense that they should have security of tenure, they should be able to work without fear or favor, they cannot be in a position perpetually where their services can just be terminated, where their office can be withdrawn from them. So it's to safeguard them that the process of impeachment was brought in, and to ensure that the process of impeachment is not merely political, in as much as they can only be removed by the will of the people, as represented by their houses of parliament. So since the intention is that such a high constitutional functionary, if he's going to be removed, is because he's lost the faith, the confidence of the people. And the people are who? They're represented by the houses of parliament. But to ensure that this will of the people is not translated into a political exigency or a political expediency, that is why the safeguards have been brought in. And the safeguards really have a very clear procedure. You have to have 100 members of the Lok Sabha, 50 members of the Rajya Sabha move an impeachment. Step 1. Step 2, it has to be admitted by the Speaker, the Deputy Chairman. Step 3, there is thereafter a panel set up by the Chief Justice of India, by the senior judges, which will comprise of a judge of the Supreme Court, a Chief Justice of a High Court, and a jurist of eminent jurist who could be selected by the executive. Now, this committee's job is to look into whether just cause, good cause exists to proceed with an impeachment at all. And this panel's inquiry will decide whether a case is made out to allow an impeachment process to go on, and that it is not purely politically motivated or is without any basis whatsoever. Once that is done, then of course, you know, the process of impeachment, where the houses of parliament meet, 2/3 majority of each house, a majority of the overall joint composition of the houses, etc. So that is the procedure, and those are the safeguards. And the major safeguard which has been introduced is, of course, the safeguard of a panel of a judge of the Supreme Court, sitting judge of the Supreme Court, a sitting Chief Justice of a High Court, and an eminent jurist should be satisfied it's a matter to take forward.
Okay.
And to go on with the process of impeachment.
Mr. Sundaram, given that the final stages of impeachment require passage by a 2/3 majority in both the houses of parliament. How do we reconcile legal findings with potential political calculations in this process? Because the Congress party has put up a caveat as well that there is a previous movement by their party where they have signatures of 50 MPs for another impeachment. So could this requirement, 2/3 majority, make genuine impeachment efforts vulnerable to being stalled?
Well, very simply put, let's understand one thing. Everybody seems to be confusing, unfortunately, a lot of people seem to be confusing impeachment as a punishment. It is not. Let me explain why I'm saying so. If a person has done an action which is susceptible of criminal prosecution, either under the Corruption Act or under any other statute, that is a prosecution which goes on and can go on, dehorse any impeachment, as long as the necessary sanctions are given as the Criminal Procedure Code requires, as the laws require. If you get those sanctions, you can continue with the prosecution. The impeachment is this. Impeachment, according to me, is far from being a sword over a judge's head. It is a protection for a judge. It's a protection for high constitutional functionaries. The protection is they cannot just be removed. Their services cannot just be terminated. Their removal requires a long procedure, an elaborate procedure, because you can't just remove them like that. So impeachment is a form of removal from office, because for various reasons, either the person is considered not fit to hold office anymore, having lost the confidence, and he's a person who ought not to continue in such a high office. And the process of impeachment is a safeguard for such constitutional functionary that he can't just be removed at a whim. There has to be this elaborate procedure followed. So from that angle, let me tell you that impeachment is really a protection. The procedure for impeachment, the elaborate procedure for impeachment is a protection of constitutional functionaries, that they cannot be just removed at a political whim or for any other reason. They can't just be played around with. And that is why you have this whole procedure. And so don't look at it as this procedure stalls their removal. On the contrary, the procedure is to ensure that they cannot be removed except for very, very good grounds and with a very strict procedure to be followed.
All right, Arimasundaram, really appreciate your time. Let me bring in Satyapal Jain, Additional Solicitor General of India, and Kapil Sankla, lawyer of the Supreme Court. Thank you so much for your time. Satyapal Jain, in the Sumitra Sen case, because that was the last time a judge, the impeachment process was carried out against a judge in the parliament, his resignation effectively halted the impeachment process. Does this precedent actually expose a legal loophole where judges can avoid formal accountability? And should the law be amended to ensure that findings of misconduct still lead to consequences even post-resignation?
You are right. In the Sumitra Sen's case, the impeachment motions was voted by the Rajya Sabha.
Yes.
And before it could be brought before Lok Sabha, the gentleman resigned. It has been pointed out by a number of jurists, writers, that there seems to be a loophole. Not only seems to be, but there is a loophole that you can do whatever you want to do, and you can save the doomsday after seeing the mood of the parliament before the final impeachment order is passed. I feel that now time has come, after the 6-7 cases of impeachment of judges have come, that something should be provided, that once an impeachment motion is moved, especially when it is introduced in parliament, then whether a judge should be allowed to resign or not, and even if he resigns, should that resignation be accepted and impeachment motion should be dropped. It's like, if I may give an example, there is a contempt notice issued to somebody, he tenders an unqualified apology, the court has the power to accept or not to accept that apology and still continue and proceed with the contempt notice. So I think time has come, I agree with you. Something has to be done, otherwise any person after doing all such things, facing inquiry, voting by one house the parliament, and what is the guarantee? Even if somebody feels that, look here, I may be in a position to manage the other house, and the last day he feels, no, it's not possible to now manage the other house, just one day prior he may resign. The whole exercise goes in futile. I think time has come when something has to be done on this issue.
Yes, and Kapil Sankla, one criticism, of course, during the Sumitra Sen case was that the judiciary had failed to act promptly before Parliament actually stepped in. It's a similar thing that's coming in this particular case as well. With the current case involving a proactive CGI recommending investigation, is this a sign of institutional maturity, or should there be a permanent mechanism for internal judicial discipline?
Well, let me put it like this. Internationally, there are professionals who take care of the accountability of judges. It is here, the mechanism is in-house, the mechanism is private, it is not to be disclosed, and we are not privy to the same. And there are two committees which are created. The first committee is that tells the president that, listen, you can please proceed with impeachment of one of our brother judges. And in Veeraswamy judgment, it was clarified that the president is bound by the order, the recommendation, or the diktat of the committee and the Chief Justice. Now, after that, the second committee that comes in is after the impeachment, who works like a trial court, takes care of the evidence, etc., and then comes to another finding. In this case, as we said, that this is an in-house mechanism, there is absolutely no accountability of an independent authority except for a jurist who comes in. So therefore, forget about this case. Let's talk about every other case that we've had. There has been instances of management withdrawal of various MPs from signing, and the kind of allegations that have been very, very serious. You mentioned the first case was, of course, the Ramaswamy case. And in the Ramaswamy case, what happened? That the gentleman refused to resign and nothing took place. And there was a stalemate and no work was given to that gentleman. And he left as it is, enjoying all the benefits of his retirement. Then we, of course, have the Sumitra Sen case. Again, a very, very interesting case, who decided to resign before the motion could be put in. Therefore, there was no accountability, there was no questioning, etc., etc. You mentioned the Gangli case, of course, I just saw that, and various other cases, including a very interesting case of Justice Nagarjuna, who was said to victimize a Dalit. Yes, in which case it failed because the MPs refused to vote, they withdrew. So these are very interesting cases, which also
total 7 cases.
You're absolutely right, sir. And which actually questions that whether we need a permanent mechanism today to take care of these allegations. Because we do know that Veeraswamy kind of put a blockage to we getting to know what these cases are. And then there is another subsequent case, I don't remember that right now, where a question was raised as to can we not see what has been the decision of the committee, and said, no, this is not a public document. This is an in-house document only for the eyes of the Chief Justice and the committee members. So all of that today perhaps brings to light a huge lacuna in the system, a huge vacuum, and a huge question as to the independence and impartiality of judiciary on one side, yes, but also the fact that are they today in a position to tell the other members of our democracy that, listen, you have to be independent, you have to be fair, you have to be open. Because what is good for the goose is good for the gander. What is good for perhaps the executive and the legislature should also be good and also obligatory for the judiciary. This is what I believe. I believe what the senior lawyer had stated, and very rightly so, that the mechanisms have been created to protect the independence of the judiciary. But in the garb of that, it should not happen that various people who have systematically misused their power and position also go scot-free.
Do you think there is a need for making that distinction about, just as the former Chief Justice Mishra was accused of administrative misconduct and arbitrary allocation of cases? That's one kind of, which were, of course, seen with political undertones as well. Do you think there is a need for making that distinction of what is financial misappropriation and how are other charges different? And how do you think this particular case and the decision by the government to bring in impeachment motion, how will that really impact the perceived integrity of the judiciary? Satyapal.
Yes. See, I totally agree with you. there are two type of cases where the allegations are of a different nature. One is, as you rightly pointed out, some judge gives a judgment or his behavior on the judicial side is not appreciated by some people. That can be a difference, a situation where there is a difference of opinion, whether it should be done or it should not be done. There can be a political motive also. But the other type of cases where the integrity of the judge becomes doubtful, where there are serious allegations of corruption, favoritism, like in the case of Mr. Ramaswamy, and as in the present case, I think in this such type of cases, there should not be any scope of allowing the man to go scot-free. All parties, all MPs, all people in the legal fraternity, outside the legal fraternity, should join hands to see to it that such a person goes to the last possible stage and actions are taken as per the law. Here in the present case, and in the case of Mr. Ramaswamy, he was a Chief Justice in my High Court. I was practiced here as an advocate. He was here. We used to hear all those things at that time also. Inquiries conducted, everything come. But the man escaped the impeachment only on political grounds because some political parties, some MPs from South said, no, why shouldn't a judge from the South be impeached? So you were not actually considering the reasons for impeachment. You were finding excuses to come out of the whole crisis. And look here, the man retired as Supreme Court judge without doing any work after that. Judicial work was withdrawn. Like in the present case of Mr. Varma, his judicial work has been withdrawn. He was transferred to Allahabad. The honorable judge could not take oath in the open. All judges take oath in the open courtroom. He could not take even the oath in the open. And now no work has been assigned to him. I don't know what compelled him. As a matter of fact, he should have resigned the very first day. Hundreds and crores and lakhs of notes burnt, unburnt or found at your residence. Had it been a case of some common man, by now this man would have been behind the bars.
Absolutely.
CBI,
Perhaps
ED,
this
all
would
agencies
become
would
a
have found
rare
him
instance, sir,
simply because he is a judge.
of judicial impeachment.
Just 1 minute. Simply because he is a judge, he is exploiting the immunity which has been given to the judges
Judicial
with a
immunity,
view
absolutely,
to
sir.
secure their independence. He is
Absolutely.
exploiting that.
Absolutely. Satyapal Jain and Kapil Sankla, really appreciate your time. Joining me now is a senior advocate of the Supreme Court and a former ASG, Vikas Singh. Mr. Singh, really appreciate your time. Justice Sumitra Sen was impeached by the Rajya Sabha for misappropriation of funds as a court-appointed receiver, but he resigned before the Lok Sabha could vote. What institutional lessons do you think, sir, were learned from that case, and have those been implemented to strengthen really the judicial accountability framework since then?
So two lessons have been, we have to take two lessons from this particular incident. One is that if there is a spot involvement of cash, like for instance, a delivery of cash, etc., or large amount of cash lying at a judge's place, then that should be exempted and FIR should be permitted to be registered in that instantly. I can understand an FIR on the basis of an allegation need not be registered till the permission of the CJI is to be taken. But where there is huge amount of cash either being delivered or found at the residence of the judge, then definitely FIR should be registered on its own. And the second lesson is that once the judges, the Chief Justice of India, constitutes an inquiry and the inquiry finds the judge guilty, then again the judge should not be made to go to the inquiry under the Judges Inquiry Act, and the impeachment should go straight away after this. So for instance, now if the parliament were to go for a voting on the impeachment, the voting can straight away happen in the monsoon session, rather than appoint the parliament 100 people signing or 50 of the Rajya Sabha signing, and then an inquiry being constituted, and the inquiry again giving him the right to cross-examine. That process should be bypassed, because if you read the Constitution does not require any. The Constitution doesn't say that this impeachment has to be subject to any law made by Parliament. So if it is not subject to any law made by Parliament, I feel that if there has already been a very credible inquiry, and the inquiry has found him to be guilty after giving him adequate notice, hearing all the witnesses, taking all the evidences, then thereafter the impeachment should straight away go on, rather than any further inquiry under the Judges Inquiry Act.
But sir, what if, as it happened in the previous case, we were talking about Justice Sen's case when he resigned before the actual impeachment process was completed. What happens in that case? Does Justice Varma then escape accountability?
So, Marya, even before this report was prepared to be given to the President of India, he had been given the option to resign. So ultimately, the whole process is to remove the judge. Now, if he resigns and goes, he has refused to resign apparently, and that's why the reason why this report has to be sent to the Prime Minister and the President to start the impeachment process.
That's right.
If he had resigned initially, this process would not have started. If he resigns in between, the purpose in any case is achieved. But the bigger problem is that the inquiry with regard to the cash that is found at his residence, because the cash is gone, we don't know who brought in the cash, for what purpose it was brought in, who was to benefit by this cash that was to come to the judge, what was the quid pro quo, who were the middlemen, who were paying this money. All that evidence has been lost in this whole process of taking the permission of the Chief Justice of India, and that is what is something which is I would say the rule of law has taken a beating in this case, I would say.
Yes, several unanswered questions. My last question to you, however, sir, would be, should there be a dedicated independent body or an ombudsman to investigate judges outside of the collegium and the executive and the legislature?
Well, Marya, that can only be done by law, and unfortunately, there is no law on the subject at the moment. But yes, the judgment of the Supreme Court, under which this independent inquiry is done, and which was done in this case by three very senior judges of the Chief Justices and Judge of the High Courts, I think this is a good way of finding out the truth, because the idea is that the judiciary has to be kept insulated from malicious campaigns, because judges have to take very many times very unpleasant decisions which affect very many very powerful people, whether it be politicians or industrialists or other big people, bureaucrats. So they are susceptible, or I would say prone to be subjected to all kinds of malicious campaigns and allegations. So to save that from the judge, I think this process is necessary. So you can't really give the open hand for the police to start investigation, because if this is going to happen, then the judge will not be fearless in deciding his matters in court, and that is not something which we would definitely want, because that will be the last straw of a strong democracy, and the biggest loser in this will be the democratic polity of this country. So I think this protection is there, but of course these cash at sight or bribe giving or trap cases, in these kind of cases there should not be any requirement of an FIR, or there could have been an FIR without naming the judge. At least the investigation should have gone on, the money should have been sealed, that room should have been sealed. I don't know how the police allowed the room to be cleaned up even before anything could be done, or even before the Chief Justice of India had an occasion to decide whether to register an FIR or not. So that is something which I feel is a huge lapse on the part of the Delhi police. They should have at least sealed the room. If the judge could give a good explanation how this money came, or if the judge could explain that this was somebody who has planted this money, that money at least should have been there for him to explain. So that is something which is gone extremely wrong in this case, and that should be something which can be corrected.
Absolutely, Vikas Singh. The nature of investigation in itself, it has been clouded as much as this entire cloud which has been around the conduct of Justice Varma. Really appreciate your time, Vikas Singh, the former ASG and senior advocate of the Supreme Court. That's all from me on this edition of The Last Word.